about whether the word regulation and the word ban were the same. And if you go back and look, and I did some research on this because I was curious about it, I went back and looked to see whether the word regulation and the word ban, how they're used by courts. And there were so many cases on the subject, I stopped counting them, okay, in which the U.S. Supreme Court and the New York Court of Appeals used the word regulation and the word ban interchangeably. In fact, in one place, the Supreme Court uses the phrase regulatory ban. Okay? So in the eyes of the Supreme Court justices and the New York Court of Appeals judges, there's no difference between a regulation and a ban. But people will tell you that these bans are not the same as regulation. And the judges bought it. Right? Because when they looked at this law, they said, oh, we can draw a distinction. A regulation says how oil and gas will be developed. But a ban says in where it can be developed. And where is different than how. Okay, now you got to ask yourself the question, if I can't do it at all, aren't they determining the how? Well, the judge didn't think so. And that, for the moment, is the law of the case. And that's what the appellate division is going to have to be taking a look at. When you have cases like this, you know, if this case was brought into my office as a lawyer before these decisions were made, and I did this, in essence, without a client, I went and looked up the statute, and I read the words. And I said, wow, I mean, this is pretty clear. The legislature did not intend zoning to be allowed. And as it turned out, as information that we received at DSEC, or from people around the state who want to know, was that most of the people who were opposing this also felt that the law said that, but it was worth a shot to delay the process to go ahead and litigate it without an expectation of winning. No expectation of winning. And yet, of course, as I said before, all litigation is a turkey shoot. Okay? So they won. And the judge bought the argument. And that's what can happen no matter how good your case is. Okay? That's the environmental covenant. That's what this dispute is all about right now that's in the courts. Is what do those words mean? All regulations are preempted except roads and taxes. And I would argue that the mining law has nothing to do with the oil and gas law.
Okay? That's not to mention the fact, I mean, that implied preemption, I mean, you probably are aware of that as well. You know, that when, if express preemption or the language of the statute isn't clear, even if a court finds that, that's not the end of the conversation. Then we can look at implied preemption, where we look at the stated policy of the act and the underlying rules and regulations of the act to see if they would be frustrated by the town doing expanded moratoriums, which in this case would clearly, then we get to the patchwork issue, which could be easily made. And then it doesn't, and then on top of that, from a geological standpoint, and I think it's one of the weaknesses in the case thus far is the geology hasn't been brought out, that there's a big difference between gravel mining and oil and gas. Because gravel mining is a fixed resource. You can tell Mr. Williams to stop at the town border. And as we discussed with drainage, compulsory integration, you can't tell oil and gas to stop at a jurisdictional boundary. I would just say, ask a lawyer this, or ask 3 lawyers the same legal question, and you'll get 6 answers.
You know, Shakespeare wrote in Henry VI was the first thing, let's kill all the lawyers.
I am curious about one thing when it comes to gravel mining. A little bit I know about it, but you can't zone out gravel mining.
Can't zone it out completely?
must be a taking issue.
There's a good example right there.
Yeah.
Well, I mean, I think that, you know, obviously the cases that the proponents of the moratoriums have banned, they cite Jew Run in another case, and, you know, and they relate to gravel mining. And the one was that they didn't ban it altogether, they just banned it in certain zoning districts. So to me, that's always been kind of an issue because, you know, I took zoning law in college, and that's extent my good expertise. But I know for when it comes to pornography, you know, if I were to want to place a pornography shop in your town, when I went to law school, which was 1996, the town couldn't prohibit it entirely from your town. They had to they could limit it and say not near schools, not near churches, but they had to be in some spot. Otherwise, it would be a violation of the First Amendment right, free speech. So I would think there's potential issues there that could be litigated.
Yeah, that was one of the questions about the fact that with oil and gas they were doing a total ban. The distinctions drawn sometimes though between with pornography and the adult industry is that there's some First Amendment protection that applies there. And even my town of Dryden, I was talking to the town supervisor not too long ago, and we have a zone for that. It's out on Route 13 at Anchor Road near the airport. But there is a zone in Dryden for that because the law says exactly that. That because it's a First Amendment free speech right, you can't screen it out completely. And I might add, you know, what would happen if the town, this is another example, let's suppose that a town government decided that in order to put a lawn sign up for a candidate, or a sign about Friends of Natural Gas, or a ban fracking sign, you had to go to the town board and get their permission to do it. And then the town board enforced that against one side only. That would raise some really interesting First Amendment cases. And I think you'd have a guaranteed winner, but again, you might have to spend money to do it. Jim?
What about non-landowners? I've got a friend that's a trucker. He was counting his entire life to have water trucks. He and his son was going to do business. Beauty's a scientist. She was looking at all the businesses she was going to get through consulting work. So there's not a taking case for them, but yet their lives are definitely hurt because of it. So what about us guys like that?
Yeah, well, what you're going to run into there is an old zoning case called Northern Lights. It's about a shopping mall in Syracuse, New York, right off Interstate 81. When they built Interstate 81, the shopping mall people sued on the basis that by putting the interstate there, they have diminished their business. And the courts ruled that that kind of an economic taking is too imprecise, and it's not total, and that they would not compensate people for it. So they do take away, often with zoning and other regulations, towns do take away economic opportunity. And the courts have, this whole thing with zoning really goes back to, it mushroomed in the 1970s. And as zoning started to move into not health and safety, but planning for businesses and planning for how people should live, you know, we started to get a lot more takings cases than we'd had. Up to then, there were very few legal takings cases. Now, since 1970, there have been a lot more of them. And one of the classic cases, and this is what I should tell you about, is called Udell, U-D-E-L-L. By the way, most of this material that I'm talking about today, if you look on the Dryden SEC website, the legal tab, we have most of this posted. And anything I don't have posted that I talk about today, I'll get posted. So you'll be able to look this stuff up afterwards instead of handouts. But Udell was a situation in Middle Neck, New York, Long Island, where a town had for years had zoned an area commercial. And there was a guy who had owned and paid taxes on that land for a long time. And then he decided he wanted to develop it, put stores in there. And there was a community outcry about his doing that. People didn't want those stores there. So they amended the zoning law, and they amended it very quickly, without much forethought, and without actually making it conform with the town's comprehensive plan. And the New York Court of Appeals ultimately said, you can't do that. Zoning is not supposed to reflect, and this is sort of a quote from them, the clamor of the public, including the majority of the public. And the ordinances should not be enacted quickly without forethought as to what you were doing. And since they were changing an existing practice that had been there for 20 years, and you can put wells in New York State if you have a permit, but under Udell, that's one of these zoning cases that if and when anybody actually challenges the ordinance itself and how they got adopted, under Udell, there's an argument to be made that when you pass a ban in response to a public outcry, because somebody shows up at a town board meeting with a petition signed by 10% of the town and demands that you do it, and you do it quickly, that you're doing exactly what the Court of Appeals said you should not be doing with zoning.
It might be why they're pushing moratoriums too. Well, another reason why they're pushing moratoriums is that they can get away from that. You think, Henry?
Yeah.
Maybe one of the viewers, whether.
Somebody else has to talk for.
No, I know from town to town that I've been telling slashing moratorium, selling sprays that have been going on and on. I have to say in Butternut, they've actually kind of done something like that. What they've done is they proposed their moratorium, the county sent it back. You have to send it to the counties around here to make sure it coincides with county, problem things. The county sends it back and says, this isn't right, you have to change all the parts about gathering rights. They edited 5 pages of it, and then they said it also coincides with your comprehensive plan. They're editing their own comprehensive plan for this moratorium treatment. It's like, what are you doing?
Yeah, when a town passes a zoning ordinance that impacts the towns around it, basically has impacts that cross town lines, they're supposed to send that ordinance to the county for approval. And counties do have some control over these ordinances. The other thing I learned today for the first time with something Energy in Depth put out was that in New York State, if 20% of the landowners in a town petition a town board, before an ordinance is enacted, demanding that they not do it, then it requires 3/4 of the town board, and a 5-member board, 4 members of the town board, to pass that ordinance. I did not know that until today.
What percent was that?
20%.
20% of the land. Now, that doesn't mean 20% of the landowners. I misspoke on that. 20% of the land represented. And included in that would be the mineral rights owners like Anschutz, who own a big hunk of land rights in my town. They would count toward that 20%.
But that's a very good point, because I didn't think about that. But if Ridgewater owned 20%, not secret county or something.
Yeah.
Which they probably do.
Yeah. Now, had we known about that, of course, they could have brought that point up before Dryden adopted the ordinance. Now I think it's too late on that.
Well, yeah, but there's a lot of others. I mean, there's
Yes.
other ones. I mean, Lawrence is thinking about their ban. I've been out.
Right.
Does it have to be an individual landowner, or could it be a representation of a coalition group?
I think it was what you have to do is you could represent other people, but you'd have to get to 20% of the land.
Our coalition, for example, represents 56% of the land in town of Vestal.
Mm-hmm.
So if all of those 160 families sign,
That's more than
that's more than enough.
That's more than enough. You could do that. I think you could represent them. If they sign on and say that you're authorized to represent them, then you do represent more than 20% of the land. And that changes the parameters a little bit, because unless somebody controls 4 out of the 5 seats, they only control 3 out of 5. In those towns, you'd be able to potentially block the ordinances.
Yeah, that's important.
I will get it posted on the DSEC website. I'll have to repost. Can we repost what EID sent? We'll get that posted so that you guys can see. Or you can go to EID, Energy in Depth, and look at their website.
Isn't there a state law that says that the town can enact an ordinance change without bringing the general public?
Well, they do have to hold a public hearing. Yeah.
They have to put it to a public vote.
No, they don't have to do a referendum. But they do have to hold a public hearing. Referendums in New York are very interesting. I looked them up once in terms of community law. For the most part, referendums are discretionary. If a town wants to put something on the ballot, they can pretty well do it. We don't have initiative and referendum in New York State. And I got to tell you, the legislature's never going to give us those. That's a very jealously guarded power of the legislature. And they're not, until we get maybe a state constitutional convention someday, we're not going to get initiative and referendum in New York. So they don't have to go to a public vote first. I wish they would, but they don't. In fact, I asked the town board in Dryden to do that. I asked them to say, instead of you guys deciding what the town wants, or looking at these petitions that people bring in, why not have a vote? Well, you're not going to get a town board to do that. That's one of their powers that they just don't want to delegate.
I can't believe that they can't enforce.
I don't know of any way to force it.
Petition. Petition.
But they're not obligated to honor your petition. They don't have to put it to a referendum.
Petition is pressure, though.
Sure.
Petition
Sure.
is pressure.
We'll make an ordinance making them do it.
And I think one thing we're missing is Mr. Floyd.
Yeah.
Mr. Floyd came up with an excellent point, just as the possibility of me being a non-attorney. If you go back to the precedent of law in the United States, most of it goes back to railroad law. The railroad law argued about water.
Mm-hmm.
When water got in a conflict with the cattle owners, then the environmentalists took over and they took over environmental law. Ag and markets is exempt from towns.
Mm-hmm.
Ag and markets are exempt from a lot of things. I think that the vote is being missed. Mr. Floyd came up with the idea. Most of the land's owned by the farmers. Why don't the farmers go and do what they want to, and let's see if they get an injunction to stop it.
Well, that's an interesting point. Yeah, you can always do things. You may do them at your peril. That's the question. Yes.
That's why every 2 years you want to make sure that you know who is running for your town board and get out and vote for.
We've lost a lot of the battle already. We've lost the information war. We're losing the time war. And, you know, we can either accept this or we can try to get our rights back. So if you find a farmer that's willing to take this on, drill a well, start producing it on his own property, the utility law says if he produces too much, he has the right to sell it. Let's take some initiative, drill some wells, sell some gas, and make the liberals stop us.
Well, the way in which towns enforce zoning ordinances is they cite you. There is a case in New York called EnviroGas. It was mentioned in the entrance case, but the judge ignored it. He kept saying that the entrance case was a case of first impression in New York. And he, even though he knew about the EnviroGas case, he ignored it. In EnviroGas, a locality imposed a permit fee on people who wanted to drill, had state permits to drill. And the New York Court of Appeals on that one said, no, you can't do that. You're preempted from doing it. Because the state has a comprehensive scheme in place. The Environmental Conservation Law, the first section of that is a statement of what the state's intent is in passing it. And one of the things it says is that the state intends to have a uniform system in New York State that will enable people to extract oil and gas from the ground. That's the purpose of the Environmental Conservation Law. These zoning regulations are in conflict with that provision of the intent. And that was, again, not really looked at by the judges.
That's the implied preemption argument.
Yeah.
They totally do the same.
Now, other states have looked at similar stuff. There's a similar situation in West Virginia to ours with a similar statute and a similar purpose. And they may have even borrowed the law from New York on this. But West Virginia recently had a case. It involved the city of Morgantown. And the city of Morgantown passed an ordinance, a zoning ordinance, that covered Morgantown and to a distance of, I think it was 1 mile outside the city of Morgantown, because it would, anything that was done there would influence Morgantown. And it was challenged, and the state courts in West Virginia found the ordinance to be invalid, because the state has a systemic, uniform intent with regard to oil and gas in the state of West Virginia. And that language is very similar to the language of the New York statute. Now, a West Virginia case is not precedent-setting in New York, but, you know, the judge was perfectly, in Rosie, in the Anshin's case, was perfectly happy to cite out-of-state cases.
That support you.
Yeah, one of which was the Pennsylvania case about home rule, which, as we talked about earlier, was superseded recently by Pennsylvania law. That he couldn't have known at the time, but that is now a fact. Okay.
Henry, I have a question.
Sure.
Will that situation, and if he uses that in his argument when it goes up to the, what is the Court of Appeals?
The appellate division will be
The
next.
appellate division. Will they then look at, if he used something that is not existing anymore in Pennsylvania law, will that work against him in the appellate?
Yeah, to the extent that when Anshin's and CHC make their arguments to the appellate division, it is perfectly proper now to bring that up. It's not a fault of the judge who wrote the original decision, but when you can argue the law in the appellate courts, and if the law has changed in the interim, you can also cite that. So I would certainly do that if I were writing a brief for those cases.
And that's why I think that the proposed home rule legislation by our state senator Jim Stewart is so dangerous.
Yeah.
Because I've had him in a room where he said, well, it's no big deal. And there are situations where home rule, I don't have a problem with, for when it applies to industries like natural gas that have inherent intergovernmental conflicts. You know, we can't have that because if home rule, his home rule law is passed, then these two cases, the Dryden Middlefield cases, will be moved. They won't have to be decided because the law will have changed.
Legislature can always change the statute.
What's that?
How about the grandfather clause?
Could they grandfather it in?
Grandfather what? The Dryden Middlefield case?
Yeah.
No. No, I mean, if a court says, if the court says in the Dryden Middlefield case, this is our interpretation of the law. If the law changes, then the game is.
But the law was in effect at the time.
Oh, well, what do you think?
That could only apply to cases that arose under that law or already pending. But anything that new that came up would be covered by the new statute.
Yeah. Anything prior to the changing of that regulation stays in effect.
That depends on what the legislature says. They can make the law either prospective or they can actually make it retrospective. As long as we're talking about civil, not criminal, they can make it retrospective. So they go back and pick up existing cases. But they need to say that if they want to do that.
Like I said before, when I could do something, a lawyer will.
Okay, a couple of things that are you need to look at for the future. Of course, future zoning cases, future takings cases, questions about what happens when you cross the town line. Those are issues that are going to come up in the future as this thing develops. And there is an interesting practical question. While all this is going on and all these delays, the energy companies have been moving into Ohio and they're going elsewhere. And one of the questions is, even if New York delays this thing, if they delay it much longer, I call it death by 1,000 cuts. If they delay this much longer, it's possible that the industry will write New York State off for the next 10 or 20 years. They can always come back. The shale isn't going anywhere. So they can do their development in Pennsylvania and do their development in Ohio and leave us on the vine for the future. And there's another legal question that operates here that's interesting. And that's what they call force majeure. If you have a lease, you've signed a lease with a company, And they cannot execute that lease because the state has gotten in the way with a moratorium, with a prohibition. That lease, and it may be usually they're for 5 years with 5 years renewable. But if the state intervenes and bans the activity, the question is, does that lease get extended? Because they can't carry out the value of the lease. If you don't extend it, the argument for the companies is they paid good money to get the lease. They bought 10 years worth of, 5 years worth of rights, and five more if they renewed. If you don't give them that time, and the lease is made to expire, then there's an equitable question as to whether they've been deprived of their rights. So there's a possibility that the courts will rule that they get an extension for the period of the ban. But what if the ban goes on for the next 10 years? The problem is that those leases sit on your title and cloud that title to your land. And so by doing that, New York State could be putting the people who've already done leases in a difficult position regarding their ability to sell their land. It's something that it's an issue that's going to come up and have to be developed out.
That's already in the courts.
Yeah.
That issue's already in the courts. Now, I say the moratorium bans are even scarier from a force majeure standpoint, because the state moratorium, again, is only on horizontal drilling with a high volume, over 8,000 gallons of hydrofrac.
Right.
If I now have, so I could argue in the cases that have been challenged, and the arguments made in the force majeure cases are that, listen, yeah, maybe you weren't able to hydrofracture the property under the current state moratorium, but you could easily come out and done seismic work. You could have drilled vertical wells. There were a lot of other things that you could have done.